Well, here's the latest wrinkle in the legal scuffle over concealed carry bans. The Department of Justice and Attorney General Bondi have jumped into the fray, standing against the extensive restrictions on concealed carry that are now being looked over by the United States Supreme Court. One of the big players here is the state of Hawaii, which just filed its response. And, unsurprisingly, they're pushing back with everything they've got. They're arguing that the High Court should steer clear of this issue entirely. They're particularly bothered that the federal government under the Trump administration decided to step in at all. Let's break down what's happening here, especially for folks in states like California, New York, and Hawaii, places actively trying to close off public access to legally carrying a firearm for self-defense. If you've been keeping up, you'll recall the Ninth Circuit Court recently weighed in on several lawsuits challenging new laws aimed at dodging the Bruen decision. These laws are crafted to quietly impose concealed carry bans. One of these legal tussles was against California's Senate Bill 2, and another was Hawaii's blanket ban on public carry. The main case right now is Wolf versus Lopez, dealing with Hawaii's concealed carry restrictions, and is inching its way to the Supreme Court for review. This case revolves around a lower court's refusal to grant an injunction, essentially stating that banning firearms on most public property is somehow constitutional under the Second Amendment. That's right. The Ninth Circuit actually decided these broad bans passed muster, even after the Bruen ruling clearly stated the right to bear arms extends beyond the home. In a move that surprised many, the Trump-era Department of Justice and Attorney General Bondi submitted an amicus brief urging the Supreme Court to consider the case urgently. They made it clear it's time for the Supreme Court to step back in and rein in these lower courts that appear to be ignoring the Bruen ruling. Their filing didn't stop there. It also touched on issues like so-called assault weapon bans and magazine capacity restrictions, signaling endorsement for the broader pro-Second Amendment fight. For many in the firearms community, this came as a welcome surprise. It's not every day you see the DOJ lending a hand to lawful gun owners, but Hawaii didn't take it well. Their most recent filing with the Supreme Court argues that the DOJ and the Trump administration are butting in where they aren't wanted. In so many words, Hawaii told the High Court to disregard the federal input entirely. So what's being challenged here? Hawaii passed new concealed carry laws in response to Bruen, but instead of abiding by the ruling, they crafted even more hurdles. Their setup requires explicit permission to carry on private property, seen through a visible sign, and the same goes for public areas open to foot traffic, places like grocery stores, shopping centers, and big box retailers such as Walmart or Target. In effect, without someone giving you the go-ahead, carrying is a no-go. And here's the catch. Even if you navigate Hawaii's rigid permitting system and by some stroke of luck get approved, that permit is barely worth anything. The list of places where you can't carry is so extensive, it effectively nullifies your right to self-defense in public. This flies in the face of Bruen, which dismantled the old may-issue policies that gave local authorities complete discretion over whether you could carry or not. Before Bruen, Hawaii was infamous for its nearly impossible permit process. During 1980 to 2018, only 4 concealed carry licenses had been granted to private citizens. In fact, one entire county hadn't issued a single permit. But Bruen changed the landscape. The court made it clear that Americans have the right to carry firearms beyond their front door. May-issue schemes, where you had to show special need, were ruled unconstitutional. The state has no right to deny you your rights just because a bureaucrat decides you don't need them. So, here we sit. Hawaii is digging in, trying to defend their fresh carry ban, while the federal government weighs in on the side of liberty. The Supreme Court hasn't decided yet if they'll pick up Wolf versus Lopez. But if they do, it could become another pivotal ruling for gun rights across the nation. Following the landmark Bruen decision, the state of Hawaii countered by enacting Act 52, supposedly to align their laws with the ruling. But instead of making matters easier, Hawaii and other anti-gun states used the opportunity to make a flawed system even more restrictive. This led several plaintiffs backed by various pro-Second Amendment groups to file a lawsuit challenging the new carry regulations. At the district court level, they managed to secure a temporary restraining order, which was later upgraded to a preliminary injunction. The court found Hawaii's rule, which bans carrying on privately owned property open to the public without explicit owner permission, likely unconstitutional and contradictory to the Bruen principles. Unhappy with that outcome, the state of Hawaii appealed to the Ninth Circuit Court of Appeals. In typical fashion, the Ninth Circuit reversed course, siding with the state and upholding the extensive ban on public carry across all private properties accessible to the public. Their reasoning leaned heavily on outdated laws, including obscure hunting restrictions and even some openly discriminatory statutes from the past, to validate the state's overreach. This cherry-picking of history became the backbone of their decision. Following that setback, the plaintiffs requested an en banc hearing, a review by a larger panel of Ninth Circuit judges. That request was rejected. However, several judges, including Judge Van Dyke and others, raised strong concerns about the court's refusal to reconsider the flawed three-judge decision. This didn't come as a shock to those familiar with how the Ninth Circuit typically handles Second Amendment matters. With nowhere left to go, the plaintiffs turned to the Supreme Court asking for an emergency review. The pressing question is whether a state can legally ban licensed individuals from carrying firearms on private land open to the public, such as shopping malls, grocery stores, or parking lots, without the owner's written permission. This case has faced long odds from the get-go because it's still at the interlocutory stage, meaning it hasn't been fully resolved at the lower court level. The Supreme Court usually hesitates to dive into preliminary rulings or injunctions, especially with Second Amendment cases. But then something unexpected happened. The Department of Justice, the Attorney General's office, and the Trump administration all filed amicus briefs supporting the plaintiffs, urging the Supreme Court to consider the case swiftly. In their filing, the federal government asserted that Hawaii's near-total ban on carry contradicts Bruen and the legal tradition it reinforced. Bruen upheld that everyday law-abiding citizens have a right to carry firearms in public for self-defense. The federal government emphasized that the Ninth Circuit distorted the historical record to uphold an unconstitutional law, and that those old hunting or discriminatory restrictions shouldn't influence modern constitutional analysis. One bold move in the government's brief was their urging the High Court to overlook that this is an interlocutory appeal and to take the case, a rare move. They even briefly touched on related issues like so-called assault weapon bans and magazine restrictions, hinting that the Supreme Court should soon weigh in on those too, although not central to this particular case. In short, this is now a significant legal battle. If the Supreme Court agrees to hear it, the ruling could further define and potentially bolster the scope of the Second Amendment in the post-Bruen era. So here's where things currently stand. Recently, the state of Hawaii filed its response to the Supreme Court petition in Wolf v. Lopez. As expected, they're urging the High Court not to hear it. Hawaii's main argument is that it's too early for the Supreme Court to get involved. They claim the case is still at a preliminary stage, centered around an early injunction with an underdeveloped evidentiary record and insufficient arguments and briefs submitted for a full review. They also pointed out there's no split among the circuit courts on this issue. Bans on carrying firearms in public spaces, which in their eyes makes the case less urgent. In other words, they're asking the Supreme Court to hit the pause button, similar to what they've done recently with other Second Amendment cases. But that's not all. Hawaii also criticized the Trump-era Department of Justice for their supportive brief. They call the federal government's amicus filing uninvited and insist it shouldn't sway the court's decision, arguing the brief adds nothing beneficial and should be disregarded. Yet their stance quickly becomes contradictory because, in the same breath, they say the Department of Justice didn't address a second question in the petition, and that omission supposedly speaks volumes. They're trying to have it both ways. On one hand, they deem the DOJ's brief irrelevant. On the other, they're spinning the DOJ's silence on a secondary issue as proof Hawaii's law should remain. In truth, Hawaii's brief struggles to counter the plaintiffs' core points. Labeling the Department of Justice as uninvited guest doesn't hold water. That's exactly what an amicus curiae brief is, a third-party statement filed by someone who isn't a direct litigant, but still has valuable insight to share. These briefs aim to provide the Supreme Court with diverse perspectives to aid their decision on whether to take the case or ultimately how to rule. Ironically, there were no complaints from anti-gun advocates when the Biden administration filed similar briefs supporting gun control laws. Back then, no one claimed the government was uninvited. But now, with the DOJ under Trump-era leadership speaking on behalf of gun rights, it's suddenly a problem. Suddenly, they're seen as intruders, their opinions irrelevant. It's a double standard, pure and simple. Now, regardless of how compelling the arguments might be, the central challenge remains. The petition still requires at least 4 Supreme Court justices to vote in favor of hearing the case, the first and biggest hurdle. The question is whether the High Court even wants to take on another Second Amendment case right now, especially one in an interlocutory phase. Historically, the Supreme Court has been hesitant to step into Second Amendment matters that haven't reached a final judgment. They've bypassed several, including cases about so-called assault weapons bans and magazine capacity limits. So they could very well sidestep this one too, merely by saying, "This is still a preliminary ruling. Let the lower courts complete the process and reach a final decision first." That outcome would be frustrating, but certainly not unexpected. Still, there's a silver lining here. The Trump administration getting involved at such a critical juncture signals that there's still weight being given to the pro-Second Amendment stance at the federal level. Hawaii might try to downplay the DOJ's input, but it's unlikely the Supreme Court will altogether dismiss a brief filed by the United States government. As this unfolds, I'll be monitoring every development and keeping you updated. Thanks for tuning in. Be sure to like, drop a comment below, and subscribe if you haven't already. Always remember, this country was built by free people, and it'll be defended by free people who know their rights and aren't afraid to stand up for them.